afternoon and welcome. I hope you all are well and looking forward to the weekend. This is a great start to the weekend and a good discussion leading into it. My name is Elizabeth Kronk Warner. My pronouns are she and hers, and it's really an honor and privilege to be here today to look at hopefully kind of a positive spin on the pandemic and perhaps what we've learned and perhaps what might be bettering the legal profession a bit better. As I like to do anytime that we're gathering together, I like to start off by acknowledging that at least where I'm at today, which is at the University of Utah, is Indigenous land. And we acknowledge that this land, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many Indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. So again, really excited to have this discussion today and have our two wonderful guest speakers. We had a chance to talk a little bit about the panel yesterday, and I can assure you that you are in for a wonderful conversation. And today's topic again is pandemic positives. So obviously, this has been an incredibly difficult year, many challenges associated with COVID-19 and also with race and racism in the United States that we have been working through as a legal community. But perhaps there are some positives too. And as we look back on what we've been able to accomplish this past year and how many of us have had to make this transition into a new online and virtual format and what's that meant for the practice of law, maybe there's some positive takeaways from all of this. So for example, I have a colleague, Dr. Leslie Francis, who does guardian ad litem work, and she shared with me that because now her representation can be virtual and we have these online platforms, she's been able to represent clients across the state. So her reach and her work has been much more pervasive than it was before. Similarly, I've heard from attorneys within our legal community who have said that they've really appreciated the opportunity to do filings via email, and that has made things a lot easier and more convenient for them and their clients. I've also heard from members of our community who have said that they've really appreciated that they can now do depositions via Zoom instead of having to travel all over the country to meet with people and to engage in depositions. So again, perhaps there's some positives, and I'm really excited that we have two guests today who are going to be talking about where there are potentially some silver linings and also potentially where there are some additional opportunities if we're able to capitalize on them. So they're going to spend about 5 minutes each briefly introducing themselves and their background and the perspective that they look at this topic from. And then they're going to have a back and forth dialogue for about 30 minutes or so after they're done introducing themselves. And at the end of that 30 minutes, which should take us to about 12:40 or 12:45, I'm going to break in, and that will be time for you to participate and to ask any questions you may have. You don't have to wait until they're done talking. If you have questions at any time, feel free to put those into the Q&A function. If you look at the bottom of your screen, you should see a button that says Q&A. And so that's a place where you can enter your questions. And then when the time is appropriate, I will be asking the questions of our panelists. So we're going to go in alphabetical order in terms of introductions and context. So first we have Michael. Michael, take it away.
Thank you, Dean. Thank you for inviting me to be part of this webinar today. My name is Michael Houlberg. I'm a manager at IAALS, the Institute for the Advancement of the American Legal System. I thought I'd first provide a little more background on what IAALS is. We're a national independent research center, located at the University of Denver. And while we're a research center, we think of ourselves as more than just a think tank, but a think and do tank. And the reason for that is that our four-step process of how we do our work. So first, we research problems that both our courts and our legal profession are facing. We then bring together stakeholders from both sides of the aisle, including self-represented litigants when we get the chance, to develop models that will help address these problems. Thirdly, we work with and empower decision makers, a lot of times judges, to implement these models. And last, we measure for outcomes and impact, and we revise our recommendations when we feel the need to. So in the beginning of 2020, my colleagues and I were working with a court in Arizona to revise their divorce and separation process to make it easier, to make it more efficient. We were in the implementation phase at the time the pandemic hit. Understandably so, we had to halt that process, or the implementation, because the court was really focused on just being able to stay open, which thankfully it was able to do. But with that experience and speaking with other courts over the last several months, we realized that both courts and legal service providers were really struggling with being able to make the transition to virtual services. So we wanted to be able to provide case studies of organizations that were successfully making these transitions so that others could learn from their examples and generate ideas of their own by looking at the examples. For this project, we interviewed 9 organizations. One of them was Judge Landau and his court. And we detailed how they made the transition to remote services. So some of those included how they messaged their changes that they were making to their customers, how they balanced the remote services with in-person needs, which is something that we'll talk about more in this, deploying existing and new technologies, how they were able to do that and the struggles that came about that. Navigating challenges. There were a lot of challenges that they had throughout the entire process and how they worked through those. And then how they leveraged partnerships, both to help themselves and to help their customers. So we combined all of this information into a publication that we called Pandemic Positives, Extending the Reach of Court and Legal Services. And through this project, I learned a lot about the successes and the struggles that these courts and legal service providers we're dealing with over the last 8 months. And so I'm really looking forward to being able to share all of those with you today. Thank you.
So I'm the presiding judge of the Salt Lake City Justice Court. And when I was thinking about, and Michael's kind of gone further into the details of this with his organization. And if I were to sum up the last 8 months in terms of the silver linings, are just the things that we were able to do are things that I think everyone, including national organizations, had planned for courts to do over the next 2 and 3 decades, that were all of a sudden just compressed into the last 8 months, and in part the first 4 to 6 weeks of the pandemic. And I think the umbrella thinking is this transition that a court is a place run by judges and that serves large institutional interest, and it is transitioning to a service that is oriented to the consumers of that service, the court patrons that the court serves, and that is a massive transition in philosophy and in culture, and it's a very difficult one, and it was facilitated greatly by this. And I'll say a set of overlapping disasters that we've had to face this year. And so the couple of things that I think at the beginning, I would say as the most memorable positives from this year is kind of fit into that scheme. So the first one is moving from thinking of court as a brick and mortar place to thinking of court as hey, let's rent a van and drive over to this encampment and see what we can do to move some of these cases forward, get some of our patrons the assistance they need so they're not picking up more of these cases. That started very early in the process. We had to shut down, so Salt Lake PD was nice enough to let us use their command unit. It's basically a camper van that we had parked in front of the courthouse, and we're able to keep things going. I'm sorry. That was something that we had planned. We were like, why don't we get a van and start servicing the downtown areas in a little more effective way? And I guarantee you it would have never happened this year, but for the pandemic. The second disaster was in the aftermath of the Michael Floyd killing. I think a lot of courts responded to that differently for whatever reason. even though we had similar occurrences over the past 10 years. And the response there, especially from the Utah courts, was, I think, pretty breathtaking, in that the Utah courts committed to having a Office of Fairness and Accountability within the main structure of the administration of the courts. And that is, I think, the only way to remedy some of the racial justice problems that we have in the U.S. A central office that is responsible for the changes that need to happen. Otherwise, it's just kind of punted to judges and individual actors doing what they can. And I think, especially with self-represented parties, there are a lot of these systemic problems that we're not going to work out our way out of if it's just, oh, there's one good actor doing some pro bono. We need a plan, and it's so encouraging to see that the Utah judiciary is doing that systemically. And again, I don't think that would have happened this summer. All of a sudden, our court, well, we put out an order, but lots of other state Supreme Courts just started putting out orders saying, look, this is something we recognize that we haven't always gotten right, and we're committed to righting that. And that's a slow process, and it's really encouraging to see. And again, I don't think that would have happened but for this crazy year that we've had. And then the third, and this is again something that I hope Mike and I will just kind of have an exchange about, is just the very court being more consumer oriented. So we had generally we're just a place, and we can order people to show up. And if they don't show up, we issue a bench warrant, and that's that. And it's kind of on to the next day. And we had a deep pause this summer when we said, we need to figure out how to reach people, because what we're doing is not working, and we're just this delaying things is not serving anyone. And so with virtual court, with using online scheduling tools, we're able to do things that, again, we would have never done, where you can say, look, instead of us ordering you to come here for 4 hours and sit until we potentially resolve your case, or you just tell us all you really wanted was a bench trial. I don't know why I had to sit here for 4 hours to wait for the judge to have an opportunity to deal with my case when it was clear what I wanted, and I've already taken a day off, and I'm really frustrated at this point. Instead of doing it that way, to just say, look, you can hop online. You can hop on from your work site. You can hop on from home. You can hop on, you've clearly just pulled over in your tractor trailer, and you've said, hey, judge, I'm working, but I'm ready to hear my case. Those are incredible benefits. And I think at this point, as we switch gears to the next phase, we just need to think about preserving the good. I think I think it was Dean Kronk Warner mentioned, private practice, there's been a lot of good. There have been a lot of depositions that you can do virtually. Obviously, there's some that you can't. And, that's always going to be a feature. We do need the brick and mortar location. We need to be able to have a trial. We need to facilitate confrontation between witnesses and attorneys. But there's so much of our work that we can automate and get onto a virtual space. And that makes it more likely that the process isn't the punishment, right? The thing that we're doing to you is not just forcing you to sit here for 4 hours multiple times over the course of a year. The process is going to be easier, and we'll just let the punishment be the punishment if it turns out that you're guilty of something. So that's my 5-minute overview. And I think, Mike, when we were just kind of chatting about this 2 days ago, Michael and I were like, well, there's another positive here, and that's that we're talking, right? I didn't know who Michael was. I didn't know what IAALS was, because I'm a fairly young judge, and I don't know when we would have met. But now, because of the pandemic, we had our court strategy was just to put up a Facebook page, put up a Twitter account, and just start pushing out information that way, because we really didn't have any confidence that our end users were actually going to our website. And so it was an easier way to get, obviously mainly in touch with attorneys, but just to spread the word about, look, this is what our most recent COVID standing order says, and this is what we're doing, and this is what we're allowing. And then that had I think the unintended benefit of getting in touch with what other courts are doing. I can follow what the Seattle municipal courts are doing. I can follow what Kansas City's doing, and they can follow what I'm doing, and we can kind of cross-pollinate in a way that would have been unheard of last year. I wouldn't just call someone in Kansas City, say, hey, let's just chat about this, but I can look at their feed and they can look at mine. So that's pretty exciting.
Yeah, I think it's been amazing. I'm pretty new to Twitter myself, and I never thought that I would be using it to connect with courts across the country. But when we were working on this project that I talked about, I wasn't following you, so it was somebody else I was following that, showed how a post you had about the doodle calendar that you had set up. And I saw, I was like, well, I have to reach out to learn more about this because it's exactly the type of thing that we're looking for. And it started this, this partnership. But that brings me to one of the positives I've really been thinking about that's come out of all of this. And that's the pandemic has forced courts to try things that have really been recommended for years, but have maybe seemed too out of the box or just too difficult at the time because of resources. But I know it was a few years ago that IAALS actually released a publication called 18 Ways Courts Should Use Technology to Better Serve Their Customers. And one of the we weren't the first ones, to think of a lot of these recommendations. They weren't groundbreaking, but there were still things that weren't really being implemented. And one of those was enabling parties to schedule hearings at their convenience. And you talked a little bit about it, but I know that with your doodle calendar and that implementation, that it was pretty successful.
Yeah, and I can just kind of fill in the details there. So we got to a point this summer where in our wildest dreams, we didn't think we'd be continuing anything past June 1st. So when this hit in March, I kind of was filling out, and this was kind of right after Rudy Gobert tested positive. I feel like that was the big moment in Utah where everyone said, oh, this is gonna impact us in ways that we didn't expect. And so I'm filling out that first COVID pandemic order, and we're putting in June 1st as the date we're continuing things to. And I'm thinking, there's no way we're not back to business. And sometime in April, this is all going to blow over, and we're going to be kicking ourselves because we're going to lose yet another month of jury trials and all this stuff that we need to do. And we kind of just said, well, so be it. We'll buy ourselves some extra time. We'll actually put June 1st for juries, but we'll, behind the scenes, continue everything by 16 weeks. So people are actually going to be scheduled into July. And then we'll just have to buckle down and do double calendars in July through the rest of the year. And then we'll be back on track in 2021. Oh boy, didn't happen that way. Just as we thought we were going to get a little bit back. I don't know if you guys remember, I'm sure you remember. I mean, May, we were looking really good, and things were getting better. And then Memorial Day hit, and we had a spike after Memorial Day that kind of tossed some of our plans. And that was when we kind of had to sit down and, I didn't read IAALS's recommendation, the 18 things that we should have been doing all along. But we had a problem, and it was, we don't have a way of getting in touch with our patrons. We had been just setting up calendars, and when people were issued citations or got orders, it was just directed, hey, you're going to get a date way off into the future. If you don't like that, give the city prosecutors a call, get together, let us know, and we'll put you on a calendar. And we got a very slow trickle of work out of that mechanism. So what we did instead was I was talking to the CIO of the Utah courts, and she was like, why don't you just put up a doodle calendar and order people to grab a slot at a convenient time for them? And I said, well, okay, let's do that. And that, that there were a couple of weeks where it was slow, and then all of a sudden we were getting, 50 bookings a day for people that, and obviously, I mean, they were court ordered to do it. It wasn't like we just said, hey, when you feel like it. But they were said, look, you got to get within the next 14 days, you're ordered to pick a time so that we can move your case forward. And it was, on the one hand, remarkably successful in that it got a lot of cases through the door, and we were able to start doing work again. But it was also remarkably unsuccessful for some of our partners, because instead of having 100 cases or 50 cases cattle call calendar where you can do everything efficiently. All of a sudden you have, oh, this is a Judge Landau case at 9:15 and Judge Robinson's hearing it because that's just how we did it in the emergency. And this is, this LDA would have had this case and now they have a case here and then a case again at 10:15 and nothing till 3:15. So it wasn't not nearly as great as if you can just go to the courthouse and assume that your 40 clients are going to be there. And the ones that don't show up are going to get a bench warrant and everyone else you're going to service as quickly as possible. So that the inefficiencies were breathtaking. On the other hand, the individuals that are appearing for their cases, the efficiency was breathtaking because they're able to take the hard hat off and say, hey, Judge, yeah, I signed up for this hearing. Here's your attorney and let me know what you want to do. And that was, it was just it was a rebalancing of what our business model was.
And that brings up a good point. And it sounds like I've been cutting in and out a little bit, so just let me know if I continue to do that. But it brings up a good point with a lot of these technologies and new services, or the way that we're implementing these services, is we're seeing it's benefiting some and it's not necessarily harming, but maybe not being as beneficial to others. And so I think that's something going forward that we're going to have to look through to see, how can we keep with, say, the doodle calendar that has been extremely efficient for certain people and maybe modify it in a way so that it can benefit everybody.
And it's a big investment, right? So our court, again, through much of the leadership that's coming over from the AOC and the central judiciary, has been very supportive with CARES Act money. So we're getting a couple of pods to put in our lobbies so that people can come in and jump on a WebEx with their attorney. Even if they don't have a hearing, they can come in and interface with the court, even though they might not have the ability to do so. What has been pretty eye-opening to me is the people. So everyone that has a hearing with us, there's always the line that says, look, if you can't use the technology, our courthouse is open and you can use any of our tech to get into your hearing. So so we do have a trickle of people still coming through court, and we have a courtroom set up with a room kit, a Cisco room kit, which is a pretty neat piece of equipment that really picks up everything that goes on in the room, and in a way that it's just the microphones, everything's excellent. And those people are the ones that are really having a challenge. Often they're people that are struggling with homelessness or struggling with mental health issues. And I think it's really made that divide really clear in my mind when I just kind of compare the type of people that are just loving it on WebEx, thinking that, Judge, this is great. You got me a time, call the case. This is my question. This is my discovery need. This is the motion I need. And they're done within 90 seconds, whereas prior they would have had to sit 4 hours for that outcome. And then the people that are really not being serviced well right now. And we learned that from the homeless center, the Wiegand Center, where we used to run our homeless court there. Now it's on WebEx, and the feedback we get from the social workers there is that, that our clients really miss the face-to-face interaction with the judges. That was a big deal to them. And it really put them at ease too, in a way that, especially if you're maybe struggling with mental health, you can make a connection with an in-person person in a way that will put their mind at ease and say, look, I know this is a challenge, and I know that we've got a lot of balls in the air here, but we're going to work through this together and figure out what the right outcome is. And that's a lot easier in person, especially with someone that might not be, is having a mental health challenge or is having other challenges in their life.
When I know when we've talked about that, you said that there's, with the homeless and those with mental health challenges in particular, that a lot of times they don't make it to the court, or it's really difficult for them to make it to the court. And you talked about, taking the show on the road. And I was thinking about that yesterday, and it reminded me back in 2018, a project that IAALS worked on. We did design sprint workshops where we brought together court stakeholders like judges, clerks, attorneys, et cetera, with self-represented litigants who've been through the divorce and separation process, because that was the topic area we were focusing on. And we split them into groups, and they talked through the issues that the litigants had faced through the process. And they picked one specific problem to tackle and then created and tested prototypes for that type of solution. And one of the prototypes that came out of this was something that they called the divorce van, which they talked about, it's a partnership with the court or as part of the court. They would travel to convenient locations like a public library, and there would be like a alternative dispute resolution specialist who'd be with the van. And parties could meet with them at the public library, make sure all the ducks are in order so like an agreement would be accepted. They'd satisfied requirements like a family law education class, reviewed their financials, and they could even electronically file their agreement right there. So they could do all of this without having to go to the court, much more convenient for them. And then go to the court just for the final hearing. But it just reminded me of, that same thing of what you're talking about. Just at the time that was seen as more of like a out of the box, that's a crazy idea, but it's really not.
And that's the thing. It's not only is it not crazy, it's really efficient. And so when we did our outreach project at one of the encampments in Salt Lake a couple of weeks ago, these are clients that are, on a real carousel, especially at low level courts like ours, picking up charges, being booked into jail, saying guilty, credit for time served, picking up more charges, and it really does no one any good. And we have a huge cost of having those people just churn through the system with 10, 20, 30 cases a year. And being able to reach out to someone and be there and say, this is the court's easy up, and Judge Robison's in that van, and Judge Landau's in this van, and here's our portable iPad stand. LDA, the public defenders, are over in that easy up, and then we have some other care providers. And by the way, here's some free food, and we've got the district court up as well. And so if you have a district court case where you need a bench warrant recalled, and get you another date, and the reception. And it didn't work until we put the food on the table, and then we just started getting people that just were like, hey, what's going on here? This is court. And then you say, yeah, you just give us your name, give us your date of birth. We're going to pull all your cases. We've got all the prosecutors on WebEx, and we're going to figure out if there's anything we can do for you today. And then sometimes the order would just be, look, say guilty to this one, we'll dismiss the others. You have to go to the Wiegand Center, which is our big kind of homeless services hub, and get an assessment. You get that done, and we'll dismiss everything and close the case. And that kind of thing can be really successful. Obviously, it can be, the person doesn't show up for their assessment, then what do you do? But at least we've made this effort of reaching out, meeting people, and trying to get these solved in a way that's different from just, look, I'm just going to issue a bench warrant. You're going to get picked up. You're going to spend a day or two in jail. Then you're going to be on video court, and you're going to say guilty, and I'm going to say credit for time served. And you're going to not really, that intervention didn't really move the ball forward.
Yeah. One another, just thinking another positive with all of this, and it goes right in line with what we're just talking about, but it's increased access both to the court and to legal services. So with this project that we just worked on, one of the organizations we interviewed was Alaska's Self-Help Center, and they have a family law education class that was always in person. And right now they're doing it one-on-one through calls, but they're working on doing it through Zoom. And the great thing about that is Alaska is one of the more rural state, or has one of the most rural populations in the country. And they're able to reach people in those areas that usually they weren't able to before. And another great thing is, with Zoom, you could potentially reach people statewide, depending on what the laws and rules are regarding that family law education class. And, if you need to be in a certain jurisdiction for each one, but just the potential to reach people in such broader areas.
Yeah, I absolutely agree. The other thing that I think has come up repeatedly is whenever someone has a negative, and there obviously have been a lot of negatives, but this is pandemic positive, so we're not focusing on that, is sometimes those observations are couched in, compared to a perfect justice system, this is not so great. And to just offer the reminder, look, we're not comparing it to the perfect system. We're comparing it to what we did on March 1st, which was not perfect either. And so, moving on to the next topic with this racial justice and debiasing, you get a healthy amount of objections to doing things virtually, and even what the Utah courts have done, which is, and I think the district court has restarted this, is having jurors in a separate room and you're on closed caption TV. So you have a different kind of link between the jury and the witness. You have the jurors in a separate room and they've got a Brady Bunch or a four square with the judge and the witness and the both counsel tables, and they're glued to that, just the way you're glued to me right now, hanging on every word. And then in the courtroom, instead of a full jury box, there's a big screen TV, and you can have and however many jurors. In our level of court, we just have 4, so it's pretty easy, and everyone gets a lot of playtime. And so the common objection is, look, you can't. That's not constitutional under the Confrontation Clause, because we have a right to have them be in person, look each other in the eye, and make a snap judgment as to whether they're credible or not. And you think, well, yeah, if we had some science that said that was a really de-biased way of making a decision, I'd be really sad about leaving the live in-person environment. But we don't. And, decision-making researchers will generally say, look, that kind of decision-making, just looking someone in the eye and making a snap judgment about them, is not generally great. And so this is, again, churned up that earth and made us think, well, what is fair? And there have been studies that have said, look, if you actually have a mask on, you're going to focus not on maybe some facial features that are going to fall on racial lines and you're going to make a biased decision, but you're actually going to listen to the words and just the words. And that might be more fair. We don't know. But this process has got us all thinking about it. And I think that's what's so great about being in this moment, because if we weren't in this moment and you said, hey, let's, as an experiment, why don't we put the jury in another room? That everyone would just say you're crazy. Whereas now we're actually in a situation where you can say, well, let's try it, let's study it, and let's see if it's any fairer than it was before.
I mean, this topic of racial justice, there's so many things that can be talked about and that still need to be looked into. I mean, as you mentioned, there are a lot of studies already out there. Just recently, I was looking at a study that was showing bail amounts, being set higher for Black defendants and similarly situated white defendants, for sentences on Black Americans being longer than those on comparable white defendants, and so there's research out there that there are biases, implicit biases that judges have, whether they want them or they don't, and, even with the best intentions. And so there are things like, online dispute resolution. If you actually were able to remove race, gender, age, and just had the important details of the case that the judge would see, would that help? It's possible. I mean, like you said, studies still need to be, a lot of this needs to be researched still, but at the same time, thinking of virtual hearings, and especially in criminal cases, you think of the idea of if the party was in their jail cell, hopefully not that's where they were, but if they were, and then there was a jury seeing that, it looks a lot more like this person is already guilty. And so there's a lot of things that we have to think through with all of this.
One of the things we're working on with the Harvard Access to Justice Lab is a study of just some of the debiasing techniques that already exist. So there are lots of model jury instructions on implicit bias and strategies that have come from lots of places, including the ABA, as to, what can you tell someone in terms of getting them to lessen whatever implicit bias. It's not an easy concept to describe. And so to run that as a trial and as a trial of trials, and having model trials where you use some debiasing strategies, and then ones where we just use the Utah Muji, which is, the extent of it essentially is don't rely on bias in making your decision today. That's it. And you say, well, we presume that they followed that instruction, so there was no bias in the trial. And I think everyone's kind of like, okay, that works. That's a clean way of doing it legally, but is it effective? Is it actually debiasing the trial? And so I think it's exciting to work on those kind of things. And our study will have jurors taking IAT tests before the trial, and then hopefully even relatively short interventions like a training, you can have it's hard to have a long lasting impact on someone, but you can have a 1 to 3 day impact on someone's level of bias by testing. And, whether you believe in the IAT is another thing, but so just a test to see, look, do some of these interventions work or do they not work? And I think the appetite for that has grown because of this year.
One, I think it's important that we just try. I mean, the only way that we will learn is by trying to do it. And clearly the processes that we have right now, while good in a lot of respects, are not perfect. And there's a lot that can be better. And so the more we try, the better. I think, this also makes me think, going away from criminal a little bit and into civil, this is pandemic positive, so we are thinking positive and not negative, but something we do need to think about is the digital divide. And while we are moving things into using technology a lot more, which is great, we have to realize that not everybody has the same tools. Not everyone has a high-speed broadband. Not everyone has a computer, a smartphone, and so we have to develop ways for people to be able to use both. And I think your court was a great example with that, with both the doodle calendar and the virtual hearings, because you made a way for people to be able to come into the court if they didn't have those tools to be able to still take part in that process.
Yeah, and I think one of the things we'll always struggle with is, let's face it, we're providing a service that a lot of people don't want. And so, we traditionally have always had people that wanted to get out of their hearings or just get a continuance. And so if we put together a really complicated but thorough system, it is, number one, some people just in trying to use it in good faith aren't going to understand how to book it or how to do it, how to click through all these agreements that you're opening up with the court. I mean, envisioning a future where, you can resolve a lot of these cases asynchronously by just working with the prosecutors and having less judge involvement, or just having the judge involved at the moment where they absolutely need to be involved. It's trickier because, someone that has a certain long-term relationship with a court and they just don't like court and they're not gonna click on it. It's a different service than if we were providing, if we're a dentist office, yeah, it's unpleasant, but everyone's like, no, we got to go. This is important to my life to go. And that's just not a lot of people's relationship with courts. They're trying to get me and I'm going to get out of it. And so I think that's at least the perception that I think you have a bigger hill to climb, because you do have at least a percentage of the people that you're trying to reach are trying to get away from you.
Yeah.
And that's on the criminal side. Again, civilly, you might find that that's easier, although usually there's at least one party in a civil case that's trying to there's a lot of gamesmanship in civil work as well. Oh, can we delay this and we don't have to have this judgment against us? Let's, throw a couple monkey wrenches towards the courts and hinder their ability to get this case resolved.
Yeah, there's definitely a lot of gamesmanship, and it's, I don't have the answer for how you fix something like that. But I think in addition to that, there's been a lot of efficiencies that I've seen, which again doesn't defeat the gamesmanship, but does defeat at least a lot of the frustrations that I think a lot of people feel when they go to court or have to go through the court process itself. With, even just something as simple, and I hear this all the time in the work that I do, but for litigants just trying to fill out forms, and it's probably even difficult for some new attorneys, but they constantly have to reach out, to legal service providers, to like legal aid or the court self-help, to be able to say, hey, I don't know how to fill out this form, and it takes a lot of the court's resources. But with the introduction of automated forms, which has been around for quite a while, but not really implemented in very many courts, litigants are now able to complete a lot of these processes all by themselves. And it benefits them. They feel better about the process. And when they feel better about the process, they feel better just about the overall system. And it puts the court in a much better light in the public's view than what you were talking about, where at times it's not.
I think another place where that applies too is that on virtual court, people are a whole lot more willing to tell me what they really think, which is, I think, refreshing for the system. When you're in a formal courthouse and in a formal courtroom and you've been waiting for 3 hours and your case gets called and then the judge says, hey, is there anything you want to tell me before sentencing? Most people just say, no, judge, just give me the sentence and I've had it. I want to leave. I got to, put more coins in the punky meter, just that kind of thing. Whereas now, they're in their living room and I say, well, you have anything else to let me know? And they say, yeah, judge, let me give you a piece of my mind. And there's not an inhibition there. And that can be, it can take a while, and it can be a lot of stuff that I don't necessarily want to hear. But I think just listening to it improves the relationship between the court and the community. And they can say, yeah, I ranted a little bit at Judge Landau, and he listened. And he tried to explain, look, that's, not what we're here to do. I know you were hoping to get this today, but this is a pretrial conference calendar, and I'm happy to listen to you because we have some time and we're not under the gun like we would be if I had 20 or 25 other people sitting in the pews waiting for their case to be called.
Well, and what I've seen and heard from litigants themselves is also this virtual format actually makes them feel more comfortable. And, they're not sitting, the judge is not raised above, they're not sitting down below, with it all being, much more formal and seeming almost more dooming to them. But it's just a lot easier, I think, for them to be able to speak through means such as, this virtual Zoom or whatever platform you want to use. And like you said, they're able to speak their mind a lot more. And it's unfortunate that in person, if they're not speaking their mind, they're not giving you all the facts of the case, and potentially it's wrong outcome. Yeah,
and they're not making the best choice. So if and we would try to do this occasionally, just instead of making someone wait for hours, just say, look, if you're absolutely intent on saying not guilty today, just raise your hand. Let's get you another court date, as opposed to making you wait 3 hours, then be arraigned. And at that point, they might say, look, I've already spent 3 hours here. This is a relatively minor charge, and I just don't have the stomach to come back. And you really don't want to take that guilty plea, but I can't tell, because at that point, the person's like, I just want to get this over with. And then the city says, well, here's the offer. And the guy says, I'm going to take that offer because I need to get out of here. And that's not a good result for justice on that day.
Well, wonderful. I've really enjoyed this conversation back and forth, and I hate to break in, but we do have some questions for our panelists. And again, just by way of reminder, At the bottom of the screen, you should see a button that says Q&A. If you click on that, you should be able to submit your question. Our first question comes from my colleague, Professor Jency Anderson, who says, can you talk about what you think the next steps are in Utah? Can you also talk about the difference between what may work in civil cases versus what may work in criminal cases, particularly those requiring jury trials?
Oof, that's a lot, Professor Anderson. I don't know that I can. I think what's going to happen next remains to be seen, right? And it really depends on what feedback we listen to. So if we listen to only our major institutional partners, I think it's just back to business as usual as soon as we can. And if we listen, I think we develop a system and a culture that says we want to listen to each individual and see what their preferences are, then I think some of these changes are here to stay. But it really, again, depends on what format we choose for, how we measure our success. Do we measure it based on how convenient it is for the judges and how convenient it is for the major players? Or do we say, no, we want a cross-section of everyone we serve and we want to cater to what's best for them? I think that's, and the rest is, I really don't know who's going to win that fight. And I don't know, Michael, what are your thoughts on the civil versus criminal? And
yeah, and I mean, I think we covered it a little bit, but just the idea of these virtual hearings, and with criminal, you have to find a way to make it so the defendant is not in a position, whether it's their background, what they're wearing, whatever, that they're not in a position where there's, the jury themselves are going to have biases by looking at you could tell that they're in a jail, maybe not their cell, but just in a jail, depending on what they're wearing. If it's just easier to keep them in the clothes that they're wearing in the cell instead of them being able to put the suit on or something like that, that those are absolutely issues that you have to worry about with criminal that you don't have to with civil. And with civil, I mean, we've seen that not jury trials, but just civil trials in general, jury or not, that it's very efficient, very effective to have parties appear over the phone. And you kind of touched on this, but one issue, especially with say divorce and separation, one issue you have with the parties is if they have kids, someone's got to watch the kids. So that's money or a family member who's taking care of the kids. You have to make sure that that's set up. Then you have transportation. If they have a car, that's good, but then they have to pay for parking. Not everyone has the money to be able to do that, and you don't know how long you're going to be there. And so it can get expensive for certain people. If they don't have a car, there's other transportation in general, having to figure that out. There's a lot of things that I think when you're working in the court, you don't think about as much because you're already in the courthouse and you're not having to get, you're not having to put the rest of your life aside to get there for just 1 hour. And so it's been very efficient to be able to do it from your home because you don't have to worry about those things.
And I think in terms of maybe some of the debiasing and other just fairness aspects of the court, a big difference is now you will have a business card of the director of the Office of Fairness and Accountability. It's much like I think what universities been doing for years with their offices of equity and diversity. And so you have an institutional player. So it's not just, hey, this is this one judge's pet project, or this is this organization that thinks we should be doing this a little differently. Now you essentially have someone where you say, look, systemically, wouldn't it be good to get, this isn't that far off, this isn't that hard, get judges a dashboard so they can check out how fair they actually are. We all think we're fair. We all think we're just the smartest people on earth that don't make any biased decisions. But we don't have any stats to back us up. And so you can, you now have this person. You say, hey, system-wide, don't you think we should have this? And the reason it's not hard is because other industries are already doing it. Whenever I did some implicit bias trainings with someone from a school system, and one of her first observations in the training, when she was asked, well, how do you know if you're doing it right? She just said, well, I just look at my stats every quarter that I get from the federal government, and I can tell if some of my schools are disciplining students of color differently. I can tell by just looking at my report. And I instantly said, oh man, Michelle, we don't have that. And we should. And I think, again, having a central office that's over that kind of project is a big difference.
All right, we have another question from Stephanie, who says, do you know if courts in other cities are working through these same issues as Salt Lake City courts? It has been my experience in the past that jurisdictions outside the major metro corridor are less interested in following the leader.
I think that's I don't know, Michael, do you think that's a valid observation or not? I don't want to wade in.
I mean, I'm not sure about other courts outside of Salt Lake within Utah. I do know a lot of courts, at least the majority of courts that I've spoken with in the pandemic, are all experiencing really the exact same issues from what we've talked about. And they're all dealing with the same thing. And I'm not quite sure what is meant by following the leader, so I don't know how to answer that part. But I think some of these courts that have had like greater technology already implemented, it's been easier for them. Some were already doing video hearings, so that was an easy transition. But with the following the leader, I'm just not sure.
And I would add that I think the courts that are in rural parts of Utah are really benefiting from some of the remote options that exist right now. And I think the ones that are obviously going to stay are the ones that really benefit judges. So if it means that the judge doesn't have to travel 8 hours twice a week to get to another court location, that's going to stay in place. And we just have to make sure that the benefits that accrue to other partners stay in place as well. So I think that, and being able to listen in on court. So I had 5 observers in court. I think they were from JPEG this morning, but I don't know. And I don't know where they were. They could have been in somewhere else. They could have, just having that as, you're on video court, and you can't just survey the courtroom and say, okay, I just see the players that are here watching today. You're really kind of more out there than you used to be. And I think that's probably a good pressure to have for all judges.
Yeah, and I'll just add, from the College of Law's perspective, we have a pro bono institute that has primarily served Salt Lake County, although we do some work in Davis County as well. And we've started to talk about, now that we've had to develop virtual ways of running those pro bono sites, of possibly expanding into rural communities that we have not had a presence in before, such as areas around Moab, where we know that there are communities that need our support. And so we certainly have started the conversation about how we can better expand into those communities that we have not traditionally served. And so hopefully we'll be able to offer some assistance to moving forward. So big thank you to Rob Jepson and Johnny Benson, who run our pro bono initiative. I want to go back a little bit, perhaps for our last question, as I see we have about 6 minutes left. The question that Professor Anderson asked of what's next, is it possible to put the genie back into the bottle? Is it possible to go back to the way things were? Or will things necessarily look different after, hopefully, knock on wood, the vaccine is rolled out and we feel safer to return to some semblance of normal? Is pre-pandemic possible post-pandemic?
Do you want me to take this first?
Yeah, because Yeah, go for it. I have to formulate how I can say what I want to say.
Yeah. So I think the answer is yes and no. And maybe that's not a great answer, but the reason being, you know, all of this virtual stuff is amazing. It's been great. It has been absolutely necessary and life-saving for many people. That being said, there are a number of people that they do best in person. They do best being able to, you know, just speaking in person, communicating, have a difficult time. Again, going back to the digital divide, it's just difficult for them even to have that technology. And so I think it's important that we keep with a lot of our in-person services that we've been providing, whether it's trials or just other types of legal services with the Legal Service Center or legal aid centers. That being said, I don't think the entire genie is going back, because we've seen how beneficial using this technology has been. The efficiencies and just being able to reach such a broader area of each state. Like I mentioned with the Alaska Self-Help Center, they're looking at, you know, they really want to be able to keep this family law education class to be able to provide this one class to the entire state instead of, you know, the hundreds, thousands of people that they were able to provide it to in just that small area. And they could provide it to thousands at a time instead of their limited room of just 10, 15, 20 people. And so there's benefits of both. And I think we've started to see what some of those are. And that's, you know, with this publication we did, that was the purpose of it, to show where the technology has been beneficial. But with other things we've talked about with biases and criminal trials, it's important to not just turn everything virtual because now we've tried it.
And I think what I'd say is, if we conceptualize court as a service, we will continue doing it this way. Courts, however, have a lot of pressure on them to not be conceptualized as a service, but to be conceptualized as a place that breaks even or makes money. And if we conceptualize it as a place that is, and we're worried about the bottom line of that particular court, and that can happen quite frequently at my level of court across the country, then we really are dependent on the efficiencies that come with treating court as a place that is there to serve judges and the big interests, because that's what makes 100-person cattle call calendars necessary. Because you can spend a lot less money doing court that way than and a lot, frankly, a lot. It is. I am often just a telephone switchboard operator where I'm running a WebEx and I can see, oh, okay, she wasn't able to get on Wednesday, but I have her phone number, so I'm going to call her on one phone. I'm going to call the interpreter on the other phone. This is not without stress for judges. And so, to the extent that we're judge-centered places, there's a lot of pressure going to be in a lot of jurisdictions to go back exactly to what we were doing beforehand. So I don't think that ship has sailed at all. I think that is a fight on the horizon that is going to play out depending on what your municipality or your state thinks about how they conceptualize court.
Well, I'll just put one very last thing, because I know we're just about out of time, but just the comment that Brandel just made is spot on. We absolutely need to improve the infrastructure. Obviously, for me in this webinar, my microphone's been cutting in and out, and so it happens to all of us. It's not perfect. We need to fix that part.
Absolutely. Well, please join me in thanking our amazing panelists. They have really enjoyed their conversation, and they've left a lot of really interesting insights and things to ponder. Hopefully 2021, we will have the opportunity to be thinking about what we should keep and what we no longer want to keep from this pandemic, because hopefully the vaccine will be in place and we'll be able to move forward. And so I really welcome that discussion in 2021 and appreciate these insights so that we can start thinking about that. This is my last webinar before the holidays, so I want to wish everybody a very happy holiday season and hope that you all have a wonderful new year. We'll see you back in January with some more programming, and in the interim, I hope everybody stays safe and stays well. Thank you so much.